Panamanian Corporation, their usefulness, advantages, and benefits. The law of Panamanian Corporation, adopted in 1927, is a version of the corporation law of the state of Delaware, United States, and since its enactment has been widely used by the international financial community due to the multiple advantages and benefits that this corporation offers in the achievement of offshore operation, among other purposes, as well as for the freedom, flexibility, and ease in their handling. Panamanian corporations are chartered mainly to operate and carry out commercial and industrial activities, acquire properties, limit the personal liability in the performance of business transactions that imply risk, or to structure the payment of taxes in foreign jurisdiction on profits from commercial transactions. Thus, Panamanian Corporation buy yachts in Mediterranean and oil tankers in Asia, own bank accounts in Switzerland and Miami, buy merchandise in the Far East, and set up trusts over properties located in Egypt or London. With these examples, we want to emphasize the multiple uses given to Panamanian Corporation and their acceptance by banks, investors, and governments in all parts of the world despite the political situation in Panama at any given moment, as was demonstrated during the 80s when Panamanian corporations were still being registered and the already existing never ceased to receive the tax benefit that Panamanian law offers, nor were they at risk of ceasing to exist or operate by government decree. Such success was demonstrated by the fact that more than 350,000 corporations are currently registered and active, and their owners and beneficiaries are, for their great part, non-resident foreign citizens that do not conduct any commercial transaction in Panama. Our experience indicates that to properly use Panamanian corporation and conduct transaction and operation with them, the users of owners thereof must know the practical aspect of their incorporation and management, which aren't easily understood from simply reading our corporation law. Considering the foregoing, we have prepared this explanatory booklet to give the reader a practical and simple guide that, apart from any legal explanation, provide basic information on the operation and use of Panamanian Corporation, stating that this booklet doesn't pretend to substitute or refrain the reader from the guidance and advice of a Panamanian attorney whose assistance is always necessary and recommended. Advantages of the Panamanian Corporation. Tax benefit. The Panamanian taxation system is based on the territorial source of income. As such, the income earned from commercial transactions conducted outside of Panama isn't subject to taxation in this country. Neither is subject to taxation income from reinvoicing from an office established in Panama, the sale of goods or services for an amount greater than that for which those goods or services have been invoiced to the office in Panama, as long as such goods or services remain abroad. This practice is known as double invoicing. Managing from an office established in Panama, transactions that are executed take place or have effect abroad, and distributing earning or dividend or shares when such dividend or earnings are produced from income generated or earned by the company outside of Panama, including the income from activities mentioned in 1 and 2 above. Granting of loans or opening of line of credit in the way of interest, commissions, or income of similar nature earned by individuals or corporations, regardless of their domicile or country of incorporation, or the place of disbursement of funds, provided that the debtors are domiciled abroad and the use of such financing isn't used in Panama. It is also exempted from the payment of taxes in Panama the income earned from the international maritime commerce and trade by owners of vessels registered in Panama, regardless of the place where the contract is executed. Interest paid banks located in Panama to any depositor from deposit located in Panama. Panamanian corporations that operate abroad can distribute all or part of their asset among their shareholders without them or the corporation having to pay taxes in Panama. Absent of government controls, other than for the carrying out of specific type of businesses and activities within Panama, such as banking, insurance, or the providing of public utility services, there is no government entity or agency that has to authorize, approve, or supervise the formation of a corporation, the amendment of its articles of incorporation, or the beginning of its operation, nor the issuing or transfer of shares or the modification of the authorized capital of the corporation, the distribution of dividend, the dissolution, winding up, or sale of the asset of the corporation is subject to government notice or approval. There is no obligation of filing any kind of statement or financial report before the fiscal authorities of Panama by corporations that do not carry out businesses within Panama. Transactions conducted abroad or the income earned from the same are not subject to report. Also, it is not necessary to register or provide before any government authority private or confidential information of the corporation, such as names of the shareholders, financial statement, and names of trustees or resolution adopted by the board of directors or the shareholders. Notwithstanding the foregoing, it will only be necessary to provide specific information to government authorities when required by them through the Court of Justice as a result of a criminal investigation or legal process. Once a corporation is chartered, it can conduct all the activities, objectives, and businesses that its shareholders or director wish as long as they do not infringe any legal provision. Capitalization. The law doesn't require a minimum corporate capital for the chartering of a corporation or for its further operation or carrying out of its objective. Neither it is required that the corporate capital be totally paid up when shares are registered in a shareholder's name. Actually, the corporate capital is only important for inscription purposes since it serves as the basis for the calculation and payment of the registration fees of the articles of incorporation with the public registry. For all practical effect, the corporate capital determines that the amount of investment that the corporation can raise through the primary issuing and sale of its shares. Based on the foregoing, the setting out of the corporate capital becomes irrelevant for corporation chartered for personal company purposes acting as holding company of personal wealth.